So yeah, today is 11th April 2025. Father, I come before you, Lord. I adore you. I respect you, King of Kings, Lord of Lords. Thank you, God, for giving me an opportunity to be able to do this class. I don't take it for granted. I pray, God, for the devices to work, the internet, laptop, and everything. I pray, God, for the participants, my participant, Nicole, to be able, God, to prepare her well. Let her prepare well in the exams the next few coming days. Let her be able, God, to do and pass. Let her be able, God, to get favorable questions, good marking favor from markers. And when the exams are out in May next month, and she has passed ready for admission, all the glory shall be yours. Honor, bless her with for allowing her to be able, God, to participate in this online class, to create content from the YouTube channel. Bless all the students who are going to watch later on the YouTube channel. Give me subscribers and views. I pray all this believing in Jesus Christ, our Lord and Savior. Amen. So, yeah. So today, we are going to look at legal opinion. Legal opinion is one of the most of the difficult area under legal drafting. So that's why I thought we look at this legal opinion, and our focus will be on the questions that have been tested from the year 2008 to 2019 to prepare the student, the people who are going to watch. So the legal opinion, this is how you do a legal opinion on the screen. A legal opinion is usually done as a form of a letter. Legal opinion is usually given to client when they are sought by the lawyer. So there is 5 components of the issue of a legal opinion which you must write. So number 1 is the facts. So facts of the case is according to the question. Then the issues. What are the issues? The issues are legal issues. You don't talk about factual issues. From the facts given in the question, you determine the legal issues. Then you do the rule of law applicable. So you put the rule of law and law that you are going to apply. On facts, you can call it facts or introduction, number 1. Application of facts and law or analysis. This is the most difficult area. So according to the facts given by the question, you must do your analysis, your legal analysis. So this is where most of the marks are given by the examiners. And then you are given the conclusion. So the main part is application of facts and law. And then the conclusion, according to the facts, to the issues that you have raised, rule of law and the facts, you make a conclusion. You advise the client. So that's how you do a legal opinion. I have a sample legal opinion on your screen. This is courtesy of Kingmaker. Yeah, so as we have said, it's done like a letter addressed to clients. It can also be done in a law firm, a legal opinion within a law firm that you look as you do as an internal memo. So introduction. So introduction, I'm going to read what was these issues. So this legal opinion on instituting an appeal against Mathare Rana Shoe Company. So we must give it a heading, what the legal opinion is. Introduction, you wish to appeal on the lower court's decision of granting summary judgment to Mathare Rana Shoe Company. You also request us to give you whether the company could be liable under the theory of vicarious liability. So he asked two things, whether he could appeal, and also the company vicarious liability. This law makes an employer liable to his employer negligent action. Facts: on a material date during a lunch hour, you are jogging while wearing a visible bright outfit. Meanwhile, Mr. Kasuku was specially driving a Mathare Shoe Company truck on opposite side of the road. When it is veered off and hit you, the incident caused you physical and emotional injury. Mr. Kasuku was visiting his girlfriend when the incident happened. Kasuku had exclusive possession of the truck keys during the working hours. However, the company never objected to his private use of the truck. You suited the suit against the company seeking compensation of the injuries sustained. The company made an application for summary judgment, which was granted. So, yeah, in an exam scenario, write facts as facts as slow as summarize the facts. So issues: whether it was lawful to grant summary judgment to the company, whether the company is under the theory of vicarious liability. So you put them as legal issues. You put a question mark. Rules: what are the rules you are going to use in this case? So this means that you must apply your knowledge on all the other subjects you have learned. And I usually recommend a student to be able to understand the Constitution, because the Constitution is the basic and the most easy document to understand. So you can rely on it even if you don't know the law. You can also quote the Acts of Parliament generally if you don't know the section. So here you apply your knowledge of civil litigation. Under 36 Rule 1 provides for summary judgment can only granted to plaintiff. We rely on the proof that the court erred in granting judgment to the defendant. So rule here, it was not enough. There was not necessary to put all this. You just quote the rule, then you go to the issues. Section 49 and 87 Traffic Act defines careless driver as a person who drives without due care and intention to road users. Section therefore defines reckless to driving at the speed to the public rely on the rule to provide Kasuku was driving. Besides, Section 35 of the Act, which provides for the concept of driver, can be inferred. The driver has to reasonably believe that the owner could have given the consent tax. We will use the rule to show that Ms. Kasuku had consented to his employer to use the truck. So in an exam scenario, I'll advise you avoid the survey of presidents, avoid the case law. They are not so necessary because this question is usually 10 marks and you need to write a lot and the time is limited. So now you back to the application. This is where now the rubber meets the road. Whether you start by the issue, the way you had identified them in issues, you are going to do your analysis here per issue, whether it was lawful to grant summary judgment to the company. You stated the lawsuit to the lower court against the company. This means that you are the plaintiff and the company was the defendant. Order 36 Rule 1 of the Tort allows a plaintiff to apply summary judgment. The remedies are private to party instituting the suit. In your case against the company, the remedy was unlawful granted to the company. So analysis and straight to the point. Whether the company is liable under the vicarious liability. Because Mr. Kasuku was overspeeding back to work where he lost control of the vehicle. leading to the accident. This means that he had failed to care duty of care to you and the road user. The company may argue that you risked by choking on the road. However, the facts indicate that the accident occurred due to overspeeding. Moreover, you took care to wear bright red jogging outfit. Following the holding Dunfam versus Silverstone, Kasuku owed you a duty of care. He breached this duty and caused you the injury. This part, the track was under the management and control of the company's employee, Mr. Kasuku. Mr. Kasuku drove the truck during lunch hour with exclusive permission. He was overseeing back to work from the meeting with his girlfriend. The company may argue that Mr. Kasuku was not acting in the scope of the employment. Facts, however, indicate that Mr. Kasuku was employed to drive the truck. Following the holding in Rakabaya Morgens and Lisa versus Sailor Hall, the company is vacatable. In conclusion, it was considered opinion that, so in an exam scenario, I would advise you do the conclusion and recommendation together. So it was considered opinion that the lower court erred in granting summary judgment to the company. The company should therefore be held liable under the theory of careless and abuse. This is because Mr. Kasuku was negligent and acted within the scope of his employment. So what is the recommendation? We recommend you that you proceed to use and appeal the decision of the lower court. You have a chance, you have a case of high chance of success. So that was Kingmaker legal opinion. We wanted to look at how it is done. So now we go to the question of the day. And I'm going to start with the latest going to the earliest. So I'm going to start with question 3. Question 3. 2017, which is, I think, is sharing on your screen. The managing partner of William and Associate, where you work as an advocate or someone you urgently can't be Rishal, has been arrested at Jomo Kenyatta International Airport. Mr. Shanil is a Nairobi-based business with a business estate in Dubai. On this occasion, he was arrested after returning to Nairobi from Dubai. He had informed the managing partner that he was arrested on suspicion of trafficking drugs, underlying that during his arrest, the police confiscated his luggage and other personal belongings alleged for further investigation, underlying that after carrying out the arrest, the police commandant in charge of JKIA in the press stated that Mr. Shani is well-known drug dealer and today is Nalake Day, in quotes, underlying that Shani denies any deals with drugs and is particularly disturbed by the statement of police commandant at JKIA. So, the managing partner has asked you to draft an appropriate legal opinion on the basis of the facts above that will be addressed in the next firm meeting in preparation for the defense of Mr. Shanil. Draft the appropriate legal opinion. So, this is a legal opinion within a law firm. So you don't do it as a letter. You do it as some opinion, internal memo. You do it as an internal memo. Yeah. So I want to project your answer, Nicole. We see. Yeah. To managing partner with them as associate litigation department. So in an exam scenario, you give them their name, you give their names, eh?
Yes.
Because they are saying here, you are the nini. You are the one who is going to do the legal opinion. So you give your name. You can suggest a name. Yeah. So legal opinion on the arrest of Bilasha on suspicion of traffic drugs. Reference made to the above subject background. On or about July 2017, Mr. Bishasha, a Nairobi-based business with interest in Dubai, was arrested at Jomo Kenyatta on allegation of drug trafficking. His belongings were confiscated pending investigation, and the press was addressed stating that he was a well-known drug dealer. Issues arising: whether a statement by the police commandant was defamatory, whether Mr. B's rights under the Constitution are infringed on. Yeah. Rule of law, the Constitution of Kenya 2010, Defamation Act, then Evidence Act. Mm-hmm. Uh-huh. Whether the statement by the police commandant was defamatory. During the arrest, the police commandant addressed the press and said the following to say, Mr. Shani is a well-known drug dealer and total. From the above statement is evidence that the statement was standardized, from where we were no facts to prove nor ascertain that Mr. Shira was indeed a drug dealer. The reasonable man in the society will believe this is true and amount to defamation as per Defamation Act. Hmm? Whether Mr. B's rights under the Constitution are infringed. The law provides that an review is unasserted until proven guilty. Further, the Constitution of Kenya stipulates that every arrested individual has a right provided under Article 49. These rights were infringed upon when he was branded a criminal even before he was available in court and pending investigation. Further, the Evidence Act allows a confiscation of Act allows for confiscation of evidence before investigation. For analysis, is the opinion that the police were right in confiscating his luggage and personal belongings pending investigation. The police commandant was fought for branding him as a drug dealer, while the investigation was still ongoing. Mr. B, so you now you make your next heading, which you did not do. You must make it either conclusion and recommendation.
Okay.
Yeah, you
I was
must
conflicted as to whether to write
yeah.
it.
Mm.
I was conflicted as whether to write it as a subtitle, so I
Mhm.
just continued after finishing on the analysis of issues.
So it's supposed to be a it's a subheading,
Yes.
conclusion and recommendation. So Mr. B has the option of filing a suit in court for defamation, seeking compensation and public apology for his tarnished name for being a drug dealer. They can only have been filed after investigation has been concluded and it has been ascertained that he's not a drug dealer. You ask favorably, minimum to associate, time taken 15 minutes. So this is a question of 10 marks. I usually recommend 25 minutes for a question of 10 marks. Yeah, you have tried. At least you could have passed. So I want to perfect your answer. Of course, I have told you that the last subheadings must be conclusion or analysis. Remember, the question is telling you what? Basis of the facts above will be discussed in the next farm meeting in preparation of the defense of Mr. Shanil. So Mr. Shanil, this is a criminal offense. This is a criminal case. The question is silent on whether the stage of during his arrest, the police confiscated the language allegedly for further investigation. After carrying out the arrest, the police commander judge pressed that Mr. Shani is well known. It is at the arrest stage. He has don't be arraigned in court. And the question is saying, discuss in the next meeting preparation for defense of Shanil. So remember, this is a criminal case. And what the commandant said is a civil case. So you don't dwell that one should not be the first thing to discuss about defamation, because the question is very specific. You are going to defend Mr. Shanir or this criminal case, but you talk about the defamatory statement in passing. So yeah, legality of the arrest, you have talked about that. You can also say that the seizure of personal property must comply with Article 31, right to privacy, and can be guided in criminal procedure code, which requires a proper search and seize warrant unless circumstances justify otherwise. So conclusion and recommendation. So there was absence of due process, public judgment through media, potential unlawful seizure of property, and reputational damage. So yeah, then what is the preparation of, what is the recommendation? Immediate legal representation during questioning and custody. So you can say filing a constitutional petition addressing the violations, or preparing a judicial review if the charges are not supported with the credible evidence. Advising Mr. Shanir on civil remedies for reputational damage. First, demand a retraction and apology, a formal demand. If the apology is not done, you do what? You file a defamation case in court. Then you can say bail release, immediate application for bail, police bond, if he has not been presented in court. Yeah, are we together?
Yes, we are.
Yeah, so we go to the next question. The next question is question 4B, July 2014, on your screen. Musa Pola is a member of County Assembly MCA for Kericho County. Musa heads the Public Accounts Committee at County Assembly. Musa Mpole, before being voted as an MCA, was border trader in Kericho, Kisii Highway. He dropped out from 10 years ago. He has approached you seeking legal advice on how many they move to impeach Kericho governor. Yeah, the governor has breached the public compliance law by awarding tenders to a private company that belongs to his cousin. He also hired staff without due process. You are denying that. So charge number one, awarding tenders to a private company that belongs to his cousin. He also has hired staff without due process, underlying also that Musa also claims that Kenya shillings 5 million is missing from the county executive accounts, underlying that Musa thinks these are grounds enough to move a motion to impeach the governor. So the research part, outline the research strategy you will adopt on the above matter. So that is in the year 2008 to 2019 theory question. Research question usually come, but our focus today is on B. Address a legal opinion to Musa Polet on his legal options and procedure he must follow to impeach the governor. 10 marks. So I want to project your answer. So yeah, July 2014, question 4B. You put the address, your reference, the Oval Office suit, General Madenge PO Box, like the way you usually do a demand letter. Your reference dated to Musa Pole PO Box. Dear sir, legal opinion on the procedure of impeachment. So legal opinion on the procedure of impeachment of the governor. So it's very specific. You ought to have said that. We are together, Nicole.
Yes, we are.
We refer to the above subject matter background. You provided us with the information stating that you'd like to move a motion for the impeachment of the Kericho governor on the following grounds: which of public procurement by awarding traders to his cousin, hiring of staff without due process, embezzlement of 5,000 from county executive. Issues are arising, whether the governor action qualify for impeachment. What is the process of impeaching the governor? Correct. Rule of law, Constitution of Kenya, County Government Act. So whether governor actions are qualified for impeachment. From the information you furnish us with, it is captured herein. It is evident the governor can be impeached on the grounds of gross misconduct, abuse of office as per the Constitution. So that is Article 181. If you don't know in an exam scenario, you state generally. Tenders are to be published to the general public to be them limited for specific individuals. Is name of patriotism. Further, the governor should be accountable on how the funds are utilized within the country, have a clear audit of the same, which is governor acts. What are the process of impeaching the governor? For impeachment process to suffice, you will be required to move a motion of impeachment before the county assembly, be a member of the county assembly. The motion must be attested, be supported by one-third of the members of the county assembly. The motion will then be debated and voted on by members of the council assembly. This, however, will only be done evidence is furnished in support of the motion and the governor has been given a chance to defend. So at least at at least 2/3 of the county assembly must pass the impeachment motion for to justify. After the impeachment, the deputy governor automatically assume office provided they are qualified to hold office. If not, the president may appoint someone from within the county. So that is not from after the impeachment, the deputy governor. That one is not relevant for purposes of exam. You just say that after impeachment, the deputy governor takes on acting capacity. The impeached governor is also liberty to challenge the impeachment at the High Court. In conclusion, we believe that there is sufficient grounds to move the motion for impeachment. So you have done well until you reach after the impeachment, the deputy governor automatically assumes office. So you say that they take office with enacting capacity, pending hearing and determination of the impeachment. So the impeachment then moves to the Senate. So that is the next thing you need to say. Is forwarded to the Senate, and the Senate can do two things: appoint a special committee of 11 senators to investigate the matter, or to choose to investigate the charges as a whole house. If the committee or the whole house will vote on every investigate will vote on every charge. If majority of the senators uphold the any of the charges by majority, the impeachment leads to governor's removal from office. Of course, he can challenge the decision in the High Court, but that was not necessary. The question is only on the process, both at the County Assembly and the Senate. Are you together, Nicole?
Yes, we are.
So, heading, you ought to have put it the recommendation and conclusion. So, what is the recommending? What are you recommending to Musapole? To gather evidence and ensure that the allegations are backed by documentary evidence. Build support from MCA. Consult the clerk or the legal department in the county assembly to help you draft the motion. Yeah. And conclusion, based on the allegation and legal framework, you have legitimate grounds to initiate impeachment process if sufficient evidence is available. The process is constitutional but political sensitive and must be followed strictly to avoid any legal challenges. Should you require assistance in drafting the motion or collecting necessary documentation, I will remain available for the support. So that's how you conclude. So you must have a heading on the conclusion. So if you could have added that what I've said, it could have even took you to 25 minutes. But the way you have done, you could have you only omitted the Senate process, which you could have okay, you could have gotten at least 5 marks, but you could have that Senate process was very, very important. So now we enter the last question of the day. Of course, impeachment process is someone who is usually on current affairs. That's why I usually recommend students or legal writing and drafting students to be very good in to be very good in current affairs, watching news, legal issues that are there, reading newspapers. It becomes very easy to draft to do this to do legal writing and drafting, and also read the constitution as a basic document. If you don't if you don't if you don't if you don't remember any statutes, you just read them. Even the constitution, you just list them. In the constitution, at least you can remember some articles. You can quote them, but be very sure the articles you are quoting are the right one. So the last question of the day, Kamau Patel was registered as student at Kenya School of Law in January 2012. In the course of the year, it was discovered that he has not been attending class as requested, and requested his friend Okoth Omar have been signing the attendance roll for him. Omar admitted this fact to the school authorities. No action was taken against Omar. So you are denying that. At the hearing of disciplinary case, the disciplinary committee refused to hear Patel, arguing that Omar's written confession was all required to deal with him. Underlying that, the committee recommended that he be expelled from school. Underlying that, the decision was communicated to him in writing in April 2013. You are an advocate of High Court, and Patel has approached you to advise him on the legal issues arising and how best to deal with them to protect his interests. So, the legal opinion will deal with it, two things, legal issues arising and how best you are going to deal with them. Question is 15 marks. So you have a lot of writing to do. So yeah. So I want to project your answer. KKLP advocates, of course, the question does not tell you the law firm name, so you are going to be to guess, to create your own law firm facts. The Oval First Floor, General Madenge, PO Box, email, telephone, our reference, Kamau Patel. So Kamau Patel is the person you are addressing to. We refer to the above matters background. On or about January 2012, you enrolled to Kenya School of Law. In course of the year, it was discovered that you have not been attending the classes and would get assistance from one Okodoma to sign the attendance registers confirmed by him during the disciplinary hearing. This led to your expulsion from the institution around April 2020. The committee refused according you fair, fair hearing, not fear, and relied on Omar's evidence strictly. Issues arising whether you can challenge the expulsion through judicial review. So you have answered only one part of the question. That's why I usually say that reading the question is very, very important. So what are the legal issues arising and how best to deal with them to protect his interest? So you have done only done with one part, whether you can challenge the inspection. So of course we know how to best to deal with them is protect our interest. How best to deal with them to protect his interest. So you have done the only the first part. So that's why I usually insist on reading well and underlining. So Nicole, what do you think is the legal issues arising?
I think I'd go with um whether the disciplinary hearing was fair.
Yes. Another one.
Uh,
So issue
I
number
think whether the
whether the
oh, it's okay. You can just proceed.
so number one is whether the disciplinary committee failure to accord you a hearing violated your right to fair administrative process. That is one. Whether the reliance solely on the third party's confession without your input amounts to a breach of natural justice. Yeah. Whether then you come to whether he has any remedy. So those were the two things, the legal issues. Whether the disciplinary committee accorded your hearing violated your fair administrative. Remember, they did not give you a fair hearing. And the number two, whether the reliance or sorry on that party's confession without your input amounts to breach of natural justice. So you come to the rule of law. The rule of law, of course, it is the Constitution of Kenya and Fair Administrative Action Act. That one you captured well. Yeah. So legal analysis, you start with the way you have put them. So we start even before we go to the what he needs to done, right to fair hearing and natural justice. Yeah. So here you have said you answer you have said whether you can challenge the expulsion through judicial. We take notice that judicial review is not commenced without merits of deletion, but the process leading to deletion. The court mostly look at whether there was illegality, procedure, impropriety, and reasonableness, and whether the principle of legitimate expectation was adhered to. From this order of certiorari can be issued to quote the deletion made. In your situation, the expulsion was carried out without giving you a fair hearing, and only part was accorded audience as per Article 47. Further, an order of a mandamus can be issued comparing the performance of duty imposed by law. Should you be successful in quashing the expulsion and if School of Law refuse to reinstate you, the same will apply to them. Conclusion, The expulsion may be challenged by way of judicial review if there is breach of due process, a lack of fair hearing, or administrative overreach. Then the same can be promptly be filed in the High Court. Yours faithfully, Wakili Shupavu. So in your rule of law, because of judicial review, you can talk about Law Reform Act, Section 8 and 9. That one I know you cannot forget. In an exam scenario where you are talking about judicial review. Yeah, so you did everything, and I think you could have passed. So going back to what I was saying, legal analysis, right to fair hearing, the principle of natural justice as the cornerstone of administrative law. So to these principles is the right to be heard. Article 47 of the Constitution provides for a fair administrative action, which could the right to a person to be given a written reason for any adverse action, a right to be heard by an administrative body, and Kenya School of Law is an administrative body. Then, the procedure of fairness is essential to component of administrative law. The decision to expel you without notice an opportunity to respond or hearing is procedural impropriety, selective disciplinary action. This is also legally significant that no disciplinary action was taken against Omar, despite his admitted complicity. Remember there, he was the one signing for him. This raises question of discriminatory or selective enforcement of disciplinary rules, which is arbitrary and may offend Article 27 of the Constitution on equality and non-discrimination. So, recommended course of action. Remember, anytime you talk about judicial review, you can also or alternative is a constitutional petition. Yeah. So always talk about that. Are you together?
Yes.
So I think this is legal opinion. I think in an exam scenario whereby you don't know the rule of law that you are going, you know the facts you are going to pick from the question paper. The issue is not, it's not difficult to get the issues, the legal issues. The problem is the rule of law and the analysis. So if you don't know the rule of law in a given facts, the facts that guide the given facts of the question, if you don't know the rule of law in an exam scenario, don't try to do that question unless it's compulsory, because you are going to fail. The rule of law part is the most important part, and the analysis, which you also lead to your recommendation. Yeah. So we have come to the end of the legal opinions. Subscribe to the channel, and God is going to bless you. Watch out for the next video.